Adjournment request, if any, from item number 1 to 4.
Wait, please, Your Lordship. I beg to mention item number 2. In this matter, I'm appearing for the state appellants.
Item number
2, Your Lordship.
2.
I'm appearing for the state appellants. We had to file substitution petition in the matter. However, it has been delayed because we have not been able to obtain the signature of the DC Amingo.
How much
Therefore,
time would you like?
we'll file it during the course of the day, Your Lordship.
Next week?
From item number 5 to 16.
Your Lordship, I beg to mention item number 9. In this case, we have filed an implement petition. My Lordship, address of the respondent are not correct and proper, Lordship. Lordship may kindly allow me to withdraw this petition and liberty to file a fresh, Lordship.
This is the fresh petition.
Lordship,
Wants to
Aye.
withdraw with liberty to file fresh. Nikhil and concept for the flat has submitted that. The petitioner has submitted that submitted on instructions that she wants to withdraw petition number 838 of 2018 with liberty to file a fresh petition. The petition number so and so is dismissed as withdrawn with liberty to file fresh. IA number so and so is disposed of.
highly obliged.
There are two IAs actually. One.
Another.
Item number 9. Achha, these are two IAs. Another IA. Dispose of both IAs.
May I please, Your Lordship. Lordship, item number 6, Lordship.
Yeah.
Lordship, on last occasion, the Lordship was pleased to put a question regarding the maintainability of this PIL, Lordship, and the authority. So far, the petitioners is concerned.
Yeah.
So, Lordship, we have filed an additional affidavit on 14, Lordship, that whether that has been tagged or not, I am not aware, Lordship.
Into it.
Item number 6, Lordship.
Okay, then concept of the petitioner has submitted that an additional affidavit is filed on behalf of the petitioner. However, the same is not available on record. The registry is directed to list the same and but to tag the same and list after 2 weeks. Yes.
Obliged, Lord. Yes, sir.
From item number 17 to 27.
Great, Your Lordships. My lords, with the consent of the other side, I beg to mention item number 21, my lords.
21.
I'm the counsel for the appellant, my lords.
Adjourn.
Deeply obliged.
May I please, Lordship? Would the consent the other side, I beg to mention 24 and 25. Kindly adjourn for that.
On 24 and 25.
Yes, my lord. On behalf of BSNL, my lord.
What are these matters? What are these matters?
I don't know the facts, my lord. On behalf of BSNL, I don't know the fact, my lord.
Adjourn.
Bless me.
Yes.
Any other request?
May it please, Your Lordship, my lord, I pray for listing of a matter on Monday or Tuesday, my lord. There was urgency in the matter, my lord, because the petitioners, my lord, they are senior citizen, the cancer patient, my lord. And my lord, their land and building has been mortgaged, my lord, who is the only residential building, my lord. And now, my lord, OTS has been arrived at, my lord, at 56. That amount has already been paid, but not in the period, my lord. So e-auction notice was issued, my lord. Your Lordship was pleased to interfere that, my lord. In the meantime, second OTS has arrived at, my lord. We are
interfered with.
yes, my lord.
What we have done.
My lord, Lordship, in the initial, my lord, e-auction was stayed, and subsequently, my lord, direction has been given to amicably settle the matter, my lord. Since we are agreed to pay the amount of 27 lakhs, the balance amount, my lord. So may I pray, my lord, this matter be taken up Tuesday, my lord.
Obliged.
May it please Your Lordship. Lordship, in item number 14, I have filed an additional affidavit. Lordship. 14, 1-4. I filed an additional affidavit. That may be called for.
40.
1-4.
1-4.
Lordship.
Has to be called for.
Yes, Lordship. Obliged.
May it please, Your Lordship. I beg to listing of a IA lordship for implement of parties in WA number 53 of 2020. Lordship, actually, I am led by the outstation council. He will be in station on 22nd of this month, Lordship. So maybe list on 22nd, Lordship.
22nd.
Highly obliged.
Meet pleases your lordship. Lordship, I beg to mention item number 31, 32, and 33, lordship. Lordship, may this matter be adjourned for the day?
Adjourn.
There is an interim order, that method.
Interim order, if any, to continue till next.
Lordship, kindly the day may be fixed on first week of September, lordship.
Yes.
Kindly obliged.
Daily list for orders, item 1.
My lord, here the challenge is, so far as the rule 4,
Some matter is pending before.
pending, my lord, in that matter, my lord, under section 73 of the Railways Act, full bench of this honorable court, my lord, held that before imposing penalty, an opportunity of being heard should be given against whom penalties sought to be levied. Full bench has decided against that they preferred SLP. In that, my lord, notice was issued, but no stay was granted.
Here, this matter is pending since this is
13.
being submitted since 2020, then
My
the
lord,
matter is pending.
the other side is saying, my lord, so far as my lord, the full bench judgment is concerned, if your lord say, I will place my lord.
But now the court has.
Then,
taken into
my lord,
consideration all
in that case, because matter was last listed on 18/7 year before on the apex court.
was that this order is made since 2020 and now 16/12/2006/3/2024, the similar round was there. Okay, concept of the parties have submitted that. The issue raised in the present petition is pending adjudication before the Supreme Court. And the decision is still awaited. Just after 2 months.
Deeply on.
Item 4.
Let me lord, sir. In this case, I have filed color number today, my lord, on behalf of the appellant, my lord. And-
IA number so and so is preferred on behalf of the appellants with the prayer to substitute the legal heirs of the respondent number 1, who is reportedly expired.
Well, appellant number 1.
Appellant number 1 who is reportedly expired.
Yeah.
No objection. We can then concept for the appellant. The respondent has no objection. Hence, the application is allowed. The legal representatives of appellant number 1 are ordered to be taken on record. Amended cost title,
My lord. I'll file, my lord.
amended cost title will be filed within a period of 1 week. What about service of respondent?
My lord. Appellant. But respondent was sufficient or completed. Last
No one has appeared on behalf of the before the Laulima court today. You have not taken steps for this service of notice.
Well, I have appeared for the first time today, my lord, on behalf of the, I'll take steps.
Full stop. It has been taken on record. It is also to be noticed that the counsel for the appellant has not taken steps for service of notice upon the respondent number 1 as directed by this court on 6/10/2023 as well as 25/6/2024. In the interest of justice, last opportunity is granted to the counsel for the appellant to take steps for service of notice upon the respondent number 1 by registered post with AD as well as by usual process, just after 4 weeks.
All right.
Item 5.
The appeal was admitted on 9/10. That will be,
Notice of respondent, sole respondent has not been received.
Lordship. ID card, neither ID card nor answer notice has been received.
We'll await
Lordship.
return of notice of sole respondent for 4 more weeks.
Lordship, there are two analogous appeals. They may be listed along with, I provide the number.
The respondents are same.
No, different from same.
Then let this notices, then we will
Lordship.
connect you.
Item 7.
My lord, kindly pass over the matter for time being. Near council will be here in few minutes.
Pass over for the time.
Item 8.
Lordship, service is not complete with regard to respondent number 3 and 4. Your Lordship.
Respondent number 3 and 4.
Yes, Your Lordship. Lordship, I may be allowed to take fresh steps, Your Lordship.
Okay, the notice issued to the respondent number 3 and 4 has not been served since long. Let consent for the applicant be, let consent for the applicant, the consent for the applicant is directed to take fresh steps for service of notice upon the respondent number 3 and 4 to registered AD. Returnable, on taking such steps, let notices be issued to the respondent number 3 and 4, returnable 6 weeks.
Item 10.
This is appeal. Is the question lordship for the amount is not by the litigation policy. But lordship here, this is the litigation policy. Lordship may close 5, there is a provision. That is the department, in spite of amount is less than the provided by the.
We have seen that, sir, but only 2 lakhs rupees, question is there. Only 2 lakhs.
Lordship, Calcutta High Court recently passed an order, keeping the law point to be open and
Because no point is always open. Okay.
you see here question number A, page 9.
Okay. This excise appeal is preferred by the appellant. By the revenue being agreed with the order letter.
2/11/23 law. Page
Being
27.
agreed with the order dated just
2/11.
Commissioner appeals. The Commissioner appeals dated 25/8/11/2011, as well as the order passed by the CTET dated 2/11/2023. Full stop. The Commissioner appeals while impugned order has partially modified the, what was the original order?
Original order, page 25. If the impugned order is partially modified, so that's not the refund amount 2,76,000.
Passed by the Deputy Commissioner Central Excise Dubri and has ordered for refund of an amount of rupees 2,76,461. In addition to the other amount as allowed by the Deputy Commissioner Central Excise Dubri. Stop. The CTET Kolkata has dismissed the appeal referred by the revenue on the ground that the amount involved in the case is below the monetary limit of rupees 50 lakhs, which has been notified by the board instruction dated 22nd of August 2019. And therefore the appeal was dismissed under the national litigation policy. Stop. Learned concept for the appellant has submitted that a substantial question of law is involved in this criminal appeal, and therefore, as per the instructions issued by the Government of India Ministry of Finance dated 26th of June 2024, the revenue can very well pursue the appeal in respect of the question of a substantial question of law. Stop. Having heard the learned concept of the revenue and after going through the impugned orders, we are of the view that since the monetary, since the amount involved in the present case is only 2,76,461, and as per the national litigation policy, the revenue is not supposed to pursue the said case. Therefore, without interfering in the impugned orders, we close this excise appeal. However, the question of law raised in this appeal is left open for decision in appropriate case.
Much of.
Item 11.
This is a repeal relating to the
Compassionate appointment.
compassionate appointment, my lord. The other side, they have been served.
Who is appealing?
Their name is there, my lord. Their name is shown in the list.
Name is shown. The concept of the appellant has submitted that identical appeals has already been admitted by this court. Hence, admit no need to issue notice to the sole respondent as he is represented through the counsel. List along with late appeal number 50/2024.
Item 12.
May it please, my lord. We've not even been served with a copy of the memo of appeal, my lord.
Today just come up for the first time. I gave him a WhatsApp copy yesterday. I'll give him a hard copy today.
That we have this.
Because today it has come up for the first time. I gave him a copy on the WhatsApp, a PDF copy. I'll give him a hard copy today.
Okay, Mr. So-and-so put an appearance on behalf of the respondent has submitted that the copy of the appeal is not served upon. Writ appeal is not served upon him. Mr. Majumdar is directed to serve a copy of the writ appeal along with the requisite documents during the course of the day, just after a week.
Could it be after 2 weeks, my lord?
File the contempt, it's pending.
Contempt is pending.
Contempt is not being taken. It's not being this. Otherwise, also we are not going to press it.
He doesn't proceed, it will be after 2 weeks. I will arrest. Right, it goes.
2 weeks.
Obliged.
Item 13.
May I please, your lordship? Lordship, in my case, your lordship, the further your lordship of the appeal in your lordship, while working as a chowkidar, your lordship, grade for employee lordship in the office of the executive engineer of Dhokwa Khana, died on 4/8/16, your lordship.
2016.
16, your lordship.
August 2016.
16. After that, your lordship, I filed an application, your lordship, on 4/1/17 before the respondent number 3, your lordship. Now the facts and circumstances, your lordship, which makes my case very exceptional and which needs only compassionate aspect, your lordship, is that, your lordship, at the time of death of the father, your lordship, he left 5 dependents, your lordship. 1 cancer surviving wife, your lordship, and other 4 children, your lordship, along with the appellant. And other 3 children are, your lordship, the minor, your lordship. And the appellant itself only just attained the majority, 21 years, your lordship. It has passed, your lordship, and attained the age of 21 years. And during the treatment, your lordship, after giving due care, proper care to the mother of the appellant, your lordship, she also died, your lordship, on 30th/11/2022, your lordship. Now, your lordship, in this process, your lordship, the appellant approached the proper authority to place her case before the DLC, but it was not done, your lordship, which compelled her to write a letter to Honorable CM of the state, your lordship. And after that only, and the guardian minister of that time, your lordship, giving due emphasis over the matter, your lordship, on that, after that on, your lordship, the matter was placed before the DLC. And 7723, lordship, the minute stated 7723 at serial number 13 of the said minutes, your lordship, my case was rejected, your lordship, on the ground that it was applied after stipulated time, your lordship. And that is the reason, your lordship, for which, your lordship, I apprised before this honorable court by way of writ petition, your lordship. And, your lordship, after considering all the facts, your lordship, the honorable single bench, your lordship, also dismissed the matter on 15/7/2024, your lordship, on 2 grounds, your lordship. That is the principal 10 of the OM dated 1/6/15, your lordship, disentitled the appellant from applying the post on compassionate ground. And the second ground is that, your lordship, delay in considering the appointment, lordship, relying on the Debarbrata Tiwari case, your lordship. Now, in the impugned judgment, your lordship, for which I am before this honorable court, your lordship, 7.4 and 7.5 of the Debarbrata Tiwari case has been emphasized, your lordship, in the impugned judgment, your lordship. And in my ground also, your lordship, I am relying on the same paragraph, your lordship, 7.4 and 7.5, but in a wider respect and in a positive way, your lordship. And may I read the paragraph, your lordship? What the 7.4, your lordship? At page number 10, your lordship.
Yes.
Lordship. As noted above, the sine qua non for entertaining a claim for compassionate appointment is that the family of the deceased employee would be unable to make 2 ends meet without one of the dependents of the deceased employee being employed on compassionate ground. The financial condition of the family of the deceased at the time of the death of the deceased is the primary consideration that ought to guide the authority's decision in the matter, your lordship. Now, your lordship, I take in the writ petition, even in this appeal, your lordship, my income certificate, your lordship. That is, lordship, with due respect, your lordship, kind your attention to the income certificate, your lordship, at page number 20, your lordship. That is my income, your lordship, which shown that the appearance income is 80,000 per year. That is, your lordship, monthly 6,000, almost 6,666, your lordship. And
Yes.
yes, your lordship, if you calculate it in daily basis, your lordship, my income, your lordship, per day almost will be 222, your lordship, 222 rupees. Where my mother has been survived with, your lordship, cancer patient, your lordship. The cost of medicine, even, lordship, more than 500 rupees, your lordship, the deadliest disease, your lordship. Now, your lordship, that aspect was not considered, your lordship. Now, again, your lordship, I come to paragraph number 7.5 of the said judgment, your lordship. Considering the second question referred to above, in the first instance, regarding whether application for compassionate appointment could be considered after a delay of several years, we are of the view that in a case where for reason of prolonged delay, either on the part of the applicant in claiming compassionate appointment or the authorities in deciding such claim, the sense of immediacy is diluted or lost. In my case, Your Lordship, with due respect, Your Lordship, the sense of immediacy and immediacy is not diluted and lost, Your Lordship, because if Your Lordship kindly consider my circumstances, my chain of Your Lordship, this thing on 17, I applied, Your Lordship. My mother survived with deadliest disease, Your Lordship. After her death, Your Lordship, I again approached, compelling the situation, I again approached the Honorable CM, Your Lordship. Again, Your Lordship, it was rejected, Your Lordship. That date of rejection, I got to know on 1/1/24, Your Lordship. After getting all the details, Your Lordship, I filed this writ petition on 10 May 2024, Your Lordship. So that delay or immediacy has not been diluted in my case, Your Lordship. Again, further, the financial circumstances of the family of the deceased may have changed for the better since the time of the death of the government employee. In such circumstances, courts or other relevant authorities are to be guided by the fact that for such prolonged period of delay, the family of the deceased was able to sustain themselves, most probably by availing gainful employment from some other sources. Still, Your Lordship, there is no gainful employment. That aspect was not considered in my case, Your Lordship. Again, Lordship, I'm coming, Your Lordship, your kind attention, Your Lordship, to the minute stated, Your Lordship, 7/7/2024, that is at page number, Your Lordship. Your Lordship. In the same minute, Lordship, at 13, Your Lordship, serial number 13, my case has been rejected. If Your Lordship kindly see the serial number 3, Your Lordship. Here, Lordship, one case has been considered after a gap of 18 years, Your Lordship. In the same minute stated, Your Lordship, serial number 3, Your Lordship, the case was placed before 10/1 died, Your Lordship. The father of the appellant died, Your Lordship, 10/1/2005. The case was placed, Your Lordship, on 23/5/2023, Your Lordship. And the same was considered, considering the financial hardship. If that case has been considered, why my case has been treated as given stepmother treatment, Your Lordship. Your Lordship, again, Your Lordship, after the Devabhuta Tiwari case, Your Lordship. One, Your Lordship, judgment of Honorable Apex Court, Your Lordship, that is Govinda Janardhan Gaikwad, Your Lordship. After Devabhuta Tiwari case, Your Lordship, one judgment, Your Lordship, that is 2023 0 Supreme SC 1273, Your Lordship.
This Devdutt Tiwari was considered.
After Devabhuta Tiwari case.
Considered.
No.
Devdutt Tiwari was taken into consideration.
No, not here, not here, Your Lordship. But here, Your Lordship, the matter was considered after a 15 years, Your Lordship. Of that here, Lordship, the paragraph number 4, with due respect, Your Lordship. There are 4 grounds recorded by the High Court in the paragraph number 4 of the impugned judgment for rejecting the writ petition filed by the appellant. The said 4 grounds as are follows. It is 15 years past the demise of the father. For 15 years, the family has survived. The sister of the petitioner has also got married. The petitioner has also got married and working as a laborer, Your Lordship. Now, Your Lordship, the fact that appellant's sister has got married has obviously nothing to do with the grant of compassionate appointment to the appellant. Secondly, appellant is not having regular employment and is working as a laborer. Thirdly, the appellant could apply only after attaining the age of majority. So this is a case, Your Lordship, after Devabhuta Tiwari case, Your Lordship. Again, Your Lordship, the one more ground, Your Lordship, that is principle 10 of the OM dated, Your Lordship. I am coming to that principle 10 of the OM dated, Your Lordship. 1615, Your Lordship. Here, your lordship, the principal 10, your lordship, says that if the application of eligible candidates remain pending and cannot be considered due to want of vacancies for a period of 2 years from the date of making such application, will require no further consideration and must be understood to have spanned their force. My case has not been rejected, your lordship, for lack of vacancies, your lordship. My case has been rejected, your lordship, due to I have applied after stipulated time, your lordship. So this clause, your lordship, my case doesn't fall under this clause, your lordship, with respect, your lordship.
Yes.
Now, here the threaten of cases, your lordship, where the matter has been considered, your lordship, giving a compassionate aspect, your lordship, 15 years, 18 years, and 16 years, lordship. In most of the threaten of before by this honorable court, your lordship. And this, the case of Rintu Kakoti, your lordship. I'm reading, your lordship, if your lordship permits, your lordship, paragraph number 4 and 5 of the judgment, your lordship. It was the case of
Yes.
when the death took place on 1814, an application was filed on 29/16, your lordship. Factually, it would be correct to arrive at a conclusion that the application was submitted at a belated stage. But at the same time, the records produced before the court reveals that the father of the petitioner died on 8/10/2014 in a road accident, in which his mother Dipali Kakoti as well as his brother Rubul Kakoti also died. As 3 members of the family died in the same accident, the petitioner was in a state of shock for a long period of time. And because of the aforesaid mitigating circumstances, there was a delay in submitting the application for compassionate appointment beyond the period of 1 year. The period of 1 year prescribed under the law is directed in nature rather than mandatory. By putting an embargo that any application filed a day after 1 year is to be rejected straight away without any further application of mine, when the attaining facts and circumstances petitioner is taken note, where 3 members of the family died in the road accident, it cannot be said that petitioner was not in the state of shock after such accident, which may have delayed the submission of the application for compassionate appointment. The records reveals that the SLC had not taken note of the aforesaid circumstances while rejecting the recommendation in a technical manner, that there was a delay in submission of the application, your lordship.
Yes.
Again, your lordship, relying on some judgment, Abdul Qasim Borbhuya, your lordship. The same has been considered, your lordship, after a gap of 15 years, your lordship. This I'm supplying, your lordship. Again, the case of Oruna Gogo, your lordship, that has been considered, your lordship. Lordship, the
Those
lordship,
are on the facts of that case.
lordship.
Now, it can't be applied universally. That
Yes,
in every
lordship.
case, even after 15 years, then why not 50 years?
Lordship, in my
The person can be, any person can apply, after his grandson can apply.
lordship,
If we
Yes.
go up to this extent,
lordship,
then by a grandson of a deceased government servant who was not even born at that time, he can also apply for that.
lordship,
In that case,
lordship.
because his family is facing hardship. So if a person is not gainfully employed or he is not earning a handsome amount,
Lordship.
so he is entitled for this compassionate appointment. It's fault of whom? If he is not earning anything, you are saying that my income is only 2,000 rupees per month and therefore grant me the income, then many persons are here who don't have a income, even 0 rupees monthly income, then they are also entitled for that on this ground.
No,
There must be some end to it. It's
Lordship,
not a vested right.
Lordship,
Depends upon many circumstances.
Lordship, it is true, but what is my case, Lordship?
Your
This-
case, your case is exceptional.
My case is exceptional on this,
Since you are not earning, this
Lordship.
is what your case is.
I-
Okay, you
I-
have not been able to earn a handsome amount and therefore your case should be considered for compassionate appointment.
Lordship, at the
It will
time,
open a floodgate. Every person will come there, I am not earning, please give me the employment. And what about the others, the unemployed persons? That can't be done.
it is my submission, your Lordship, because my case, why, your Lordship, with due respect, your Lordship, my case is why I'm saying, your Lordship, because at the time of death, your Lordship, the cancer surviving patient was there, your Lordship. I am only just 21 years, your Lordship. 3 other minor children are dependent on me, your Lordship.
Yes.
So that reason, your Lordship,
all?
then they, Lordship.
This writ appeal is filed by the appellant being agreed with the order dated 15/7/2024 passed by the learned single judge in writ petition number 394/2024. The appellant has approached the writ court with the prayer to issue direction to the respondent state to provide him appointment on compassionate ground. Full stop. The father of the appellant died in harness on 4/8/2016 while working as chowkidar in the establishment of the executive, in the office of the executive engineer, Dakhu Khana division in bracket irrigation. Full stop. The her kar dena, she is lady. The appellant has filed an application for compassionate appointment before the respondents on 4/1/2017, that is admittedly after the period of limitation as prescribed in the various orders issued by the state government. Full stop. When her application was not considered, she approached Honorable the Chief Minister and the Guardian Minister, and as per their directions, the application was taken into consideration by the district level committee. The district level committee has rejected the application of the appellant, treating it time barred in its meeting dated 7/7/2023. Full stop. Against the said decision, the petitioner, the appellant has filed writ petition. The learned single judge, taking into consideration the said facts and also taking into consideration the observations made by the Honorable Supreme Court in the state of West Bengal versus Devbrat Tiwari, civil appeal number 8842-8855 of 2022, decided on 3rd of March 2023, has dismissed the writ petition filed by the appellant. Learned counsel for the appellant has submitted that looking to the exceptional circumstances in the case of the appellant, her application seeking compassionate appointment ought not to be dismissed by the, ought not to be rejected by the state authorities. It is contended that the learned single judge has not taken into consideration those exceptional circumstances and has dismissed the writ petition filed by the appellant illegally. Learned counsel has submitted that though in Devbrat Devbrat Tiwari Supra, the Honorable Supreme Court has held that delay of several years, either on account of the applicant or the authorities concerned, is not the sole factor which is to be taken into consideration, but taken into consideration, and the expiry of long period after the death of an government employee is also to be taken into consideration, so that consideration for the purpose that if the dependents of the government employees have survived for such a long period, then the requirement of compassionate appointment is diluted. However, she has submitted that the Honorable Supreme Court in Govind Janardhan Gaikwad versus State of Maharashtra, Civil Appeal number 7489/2023, SLP Civil number so and so, decided on 16/11/2023, has taken, has observed that considering the concept of welfare state, the delay in filing, the delay in applying for compassionate appointment cannot be a ground for denying the relief to a suitable person. Stop. The counsel for the appellant has therefore submitted that the impugned order be set aside and the writ petition filed by the appellant is be ordered to be allowed, and the relief period for in the said writ petition be granted. Stop. Having heard the learned counsel for the appellant and after going through the material available on record, we are of the view that in the facts and circumstances of the case, the appellant, the facts and circumstances of the case, the learned single judge has not committed any illegality in dismissing the writ petition. Full stop. It is true that in Govind Janardhan Gaikwad, the Honorable Supreme Court has ordered for, has granted relief to a person who has approached for compassionate appointment after a delay, but the facts of the said case are not applicable in the present case. Hence, we don't find any case for interference. This writ appeal is therefore dismissed.
Item 14.
May I please your lordship? Lordship, before my learned friend start, lordship, we have instructed to adhere in this matter, lordship, for the private respondent, lordship, but the lordship problem is that leading counsel, Mr. Excise, is out of station today. Lordship, may kindly take up this matter on Monday, lordship.
Lordship, I have prayer for interim prayer, Lordship. Lordship may be kind.
Lordship, may kindly consider on Monday, lordship.
Lordship, Monday then. Lordship, actually, they have filed a contempt petition which is listed on
Tuesday, lordship.
Tuesday, Lordship. Monday.
May kindly take up on Monday, lordship.
Wonderful.
Deeply obliged.
Pass over meter 7.
Yes.
To cut the long story short, I would like to point out one thing. That their case is now after abandoning the claim of regulation. Their claim is that these people were placed under the contractor by the BSNL. Apart from making that bold statement, nothing on record that they were placed by the BSNL under contractor. If that is so, they can show any evidence, we concede. Let them show on that. And unfortunately, my lord, this is the third time. That finding is never given by the tribunal. If there is any document or any letter, let them show that we have placed. And perhaps then we'll be bound by them. So many big papers and all that, but necessary. Moot question is never decided. And for that, again and again. Third time we have come here, again and again it is being sent.
Paragraph 10 of page 202.
And we have taken that point in our WS.
Page 202 of the affidavit filed by them.
Lord, page 202 of the affidavit filed by the respondent. Paragraph 10, page 202. May I read it, maybe?
Yes.
That with regard to the statements made in para 4.8 of the application, this is our written statement. The answering respondents state that the allegation made in this paragraph and in Annexure 8 of the OA are misleading and baseless for the reasons as stated herein above. The 24 numbers of casual laborers were engaged on full-time basis and they were being paid through a role of BSNL. However, as per the corporate office letter number dated so and so, the mode of payments through a role has been stopped. It is further stated that BSNL has discontinued any part of the time, daily wage or casual basis engagement, including all the applicants after the finalization of tender for supply of contract labor on present. Hence, the question of placing the applicants under contractor as contractual labor does not arise. As all the labor requirements are being supplied by the contractors, the respondents also state that the question of conferment of temporary status and regulation is a matter to be dealt with within the strict parameter of the scheme of 1989, which is not an ongoing process, rather was a one-time measure. Any other extraneous reasons like difficult terrain, etc., could not be attracted to override the provisions of the scheme or to extend the benefit beyond the scope of the scheme. And engagement of casual labor at any point of time outside the scope of given criteria under the said scheme would not attract any legal right of any such person to claim regulation or conferment of temporary status. So let it go back and let them give the finding on that. This was our specific stand. This was never decided in last 3 years. And there was a direction to decide it every time. Moreover, your lordship will see if it was 2007, what makes them to wait for 2 years and come after 2 years, 2009, wait. That is the moot question, Miller. We cannot escape the responsibility if they can show evidence that we have placed their services under the contractor. There may be some letter, there may be some agreement. Moreover, my lord, they have shown that position true to knowledge. These things cannot be treated like that, my lord. There must be some evidence. I do not want to shut them out, my lord. If that is true, let them go and let the tribunal give a finding on that. Every time they escape that. And it's not possible for legal development. I will but forward the program. Yes, 2007.
You mean to say that they were never placed under the contractor at any point of time?
They left on their own.
Now come to para number 5 of the impugned judgment.
Please.
Page 77.
May I read it?
Yes.
Further, in file number 642-1, maintained by the BSNL authorities, it has been clearly mentioned, wherein that 54 casual employees who have completed 240 days of work each year for 3 years as on 38/2004 are entitled for productivity link incentive, PLI, and accordingly all the applicants were paid PLI for the year 2003, 2004, and 2004. Annexure 1 of the rejoinder filed by the appellants against additional written statement filed by the respondent number 2 to 6. Subsequently, when the matter was pending before the higher authorities, the BSNL authorities had withdrawn 52 number of casual employees, casual applicants, and 2 other casual employees from their work on 2000, and from the same date, they were placed under the contractor for the same work, which they were doing all along, and retained 174 numbers of casual employees from the list of 2028 numbers of casual employees under BSNL. Out of 274 casual employees, 150 numbers of casual employees are much junior to the applicants. However, those 174 employees on being paid daily wages of rupees 234 whereas the appellants are being paid daily wage rupees 180 only. Thereafter, the applicants have filed various representation to the
So
authority.
there is a specific finding of this tribunal that they were placed under the contractor by the BSNL, though
That
they.
is what they say, my lord, that is mentioned in there.
No, this is the facts that they have mentioned. This tribunal has not even recorded any argument of any of the parties. They have simply, tribunal has not recorded any submission on behalf of the parties. And only on the basis of the record, these observations are made.
Let us see those records.
You just see this letters dated 31/3/2024, 2000 annexure 1 rejoinder so and so. That is there.
That lordship will find, that particular document, lordship will find in my written, in my reply, page number 307.
307.
Yes, it is there. The recording is there.
The
Yes,
document which
yes.
is under
Yes, scheduled laborers who have worked for at least 240 days for each year, 3 years or such and such enter for PLI.
307.
Yes, 307 of my this bunch. Affidavit. This is a typed part.
Just a.
This is, my lord, photocopies of the note sheet without referring to the file.
So just productive labor incentive for kind perusal where the PLI sanction. Casual laborers have worked 240 days for the 3-year PLI.
Second line is 54. These people, 54. Now they are 39. Second line of this page, 307.
Yes, 54, where is the mention of 54?
Second line. Yes. Second line.
Left out casual mazdoor.
54, 52 has approved the CAT, my lord. And CF died and 10 left, now 39. This from this 50, from the list, it is names are there.
Please,
I'll show.
please. Please.
It's 307.
Where is that list?
My lord.
List?
That list, my lord. My lord. Lordship, you may kindly see that list. Page number 192. Page 192. This list, my lord. My lord, please come to 184. Then what is this list? You will come to know, my lord. This
190.
list was sent to New Delhi headquarters. This list containing names of 220 employees. Their name appears from 151 to 174 in the list.
Your clients.
My client from 175 to 220, and those 20 persons, other persons from 151 to 174. Please come to 184 first, my lord. 184 page number. Lord, you will see.
No, just a minute. This 175.
Yes.
Gangfa Wangu and this Anant Deka, these are the applicants.
My lord, page number 192.
192 last.
Yes.
175 is.
Yes. From 175 to 228. These are these 54 persons.
These 54 persons.
Yes. Those 50 persons.
228.
Yes. Those 50 persons. Out of 228, those 54. And Lord, you will say another thing, my lord. Just above 175, kindly see. Just above 175.
Yes.
Number 192.
Yes.
Yes. From 151 to 174. Lordship remembers in the questionnaire. Page 192, serial number 151 to 174.
Yes.
Lordship is seen?
Yeah.
Now, my lord, lordship can see there. These people are, my lord, 20 persons working along with us. They've been retained. And what they did in the made in the statement in the WS in page number 343, my lord, 343 in my place, kindly see, my lord. It will be clear. Page number 202, my lord, first, kindly see of my page. 202. The question and the answer, lordship will get it here only. Paragraph 10 of the WS 202 page of my affidavit.
202.
Yes, yes.
Yes.
In the middle, lordship is read, just now my senior counsel read, my lord. It is further stated that BSNL had discontinued any part-time, daily wage, casual basis engagements, including all the applicants after finalization of tender for supply of contract labor on 2707. Lordship has seen this?
Yes.
Now what they say? They say they started disengaging. But that list of 228, except we, none of them are disengaged. And that they have answered, my lord, in page number 300, page number 344. Lordship McCallum, 325, please come. 2-3 places they have made statement. 325 with questionnaire.
Yes.
My lord. See that first sentence, my lord, subject just below that paragraph. With reference to the subject cited above, the following facts are as below. Casual laborers under BSNL are paid 18,423 per month, whereas contractual laborers under contracts are being paid 8,873. That's what, for 15 days. What they did, out of 220 days, the persons who have been placed on the contractor, they have been allowed to work for 30 days, but they are being paid for 15 days. That's another issue. I am not on that today. See the next sentence. Point number 1. Whether any person from list A, B have been conferred temporary status. This 6A, B is, my lord, that list of 228. What's the answer? No. Now, lordship has seen that. Again, kindly see point number 2. Whether there are any casual laborers without temporary status who are still working in Circle Arunachal and who are being paid directly on the BSNL. List A. Please come to the next page. Please, next page, my lord.
Yes.
This 20 persons. Right, my lord? Lordship got it. Now, please come to page number, my lord, 192. Please keep this page ready, my lord, 326. I'll compare. Please come to 192.
Yes.
192. Yes. Now, kindly see serial number 1, Assam Wangsu. This lordship will compare. See, my lord.
Serial number?
Serial number 1 in page number 326 in that list. They are now saying, first they're saying the WS, nobody is working, no temporary, nobody. But this one here,
Assam Wangsu. Yes.
Assam Wangsu. Please come to page number 192, serial number 163. 163.
Yes.
See the name, my lord, Assam Wangsu, right, my lord?
Yes.
See the next one. Ajit Devri, 153. Please come to this page. 192.
Yes.
153, Ajit Devri. Lordship has got it.
Page 150.
3.
Ajit Devri. Yes.
Next, kindly see. Anju Shaikia, 158, serial number 192. 158.
Yes.
All these people, my lord, from this list, without temporary status, still today they are working. If they are getting salary for a whole month, and when now we have been ousted after the judgment, although the judgment, it was directed, my lord, within 4 weeks, they should take us back. Instead of taking us back, we are no longer in service now after the judgment, my lord. And these people kindly see the stand. In the WS, they say, we have not granted temporary status to anybody. And those who are got without temporary status, all are ousted. Where? This page doesn't say so from the records. And my lord, kindly see another page. See the statement before the CAT, my lord. One page. Well, just a minute. I'm just showing to lordship, my lord. My lord, that's file number above. My lord, please come to page number 322.
300.
22. Specific stand
and specific statement before the CT by the BSNL. Annexure N, page 322.
Yes.
Let me read, my lord. Such as assisted by DP Bora, has vehemently submitted that by forwarding letter dated 3304 6A6B, those list, my lord. A list regarding status of pending cases of the casual laborers for regularization as on 33/24/04 was circulated, wherein, except the applicants, BSNL has kept other junior employees with them in the year 2007, whereas applicants were put under the contractor. See the next sentence. However, as per Mr. Pathak, learned BSNL counsel for the respondents, those persons who are only retained in the BSNL in the 2007, who were granted temporary status only. So she was seen, my lord. Just now I have shown to your lordships, my lord, that page, serial 20 boys. Different, absolutely to stand, my lord. In these 14 years now, on this issue we are fighting only. 14 years from 2009 onwards. And lordship, my lord, that file number, my lord, A642, note sheet 1 to 6, my lord. That file is not in respect of placing of the contractor actually. If your lordship can, that was why we placed it. Because in that file, there's a recording by the BSNL authorities that we have worked for 240 days, so we get PLI, certain bonus we get. It has got nothing to do with the placing of the contractor on that issue. And now, last occasion, we have given up that issue. We don't want that money also. Leave it. We just want to be under the BSNL, my lord. This is the case. And my lord, so what this 342 file is concerned, repeatedly in the before the CAT they said it is not in existence. It is not traceable, not in existence. It is recorded by the honorable tribunal, my lord. And when I file this one, my lord, that records, photocopies, my lord, and before this honorable court, I think that very fast day, my lord, they say it is there, my lord. Then lordship asked that question. Oh, now the file has come up. I still remember, my lord, past day. 13 invoice only.
Yes.
My lord. So the judgment, my lord, detailed judgment, if I read the judgment, will my lord.
But in order to find out those 39, also must be pointed out who are these 39.
List is there, 192.
Those 39, they have implemented only the in the writ petition. Now, those 39 only, they have implemented in the writ petition. I will give the number, my lord.
That list, this 180 starts from 184. And this, the names of these persons are appearing from 175 to 228.
In between is there.
And out of this list, 20 persons you have granted temporary status. This is your document says. He has demonstrated it.
So they were not working, you know, at that point of time.
This document is there, sir. This 322 page. Sorry. This.
Affidavit.
My lord, one thing. What lordship is
325. 25. Annexure P. Whether there are casual employee with PSM status who are still working in the BSNL or Arunachal who are paying directly by the BSNL, list enclosed annexure A. And this annexure A includes those persons whose names are figured in this list, page 144, 184.
The very first name of Vidyadhar Tati in this case. Sir, 193 pages of Mokamo naam ke tha. 193 pages of invisible naam pabo.
This finding is based on this. Equal file 640 that will confirm we get mentioned to us. If finding is based on this without the records, only the yes. So that order sequence. Yes, is people of order to this place before the court. Without referring to the pilot as a
Serial 198.
Level 3.
Yes.
Lord, the paragraph 5 is based on, Lordship will kindly see on the record, is a A642 PLI for casual motion.
This one.
I think so.
Yes, yes.
Yeah.
Yes, sir.
Page. So you are disputing these documents which we have referred. These are not the documents of BSNL.
No, my lord, our problem is that this record is a photocopy of the note sheets, but not referring to the files.
Sir, please kindly consider page 184. Come to page 184.
Yes, really.
This is the letter. This is the letter 30th of March 2024.
Yes,
Now come to last para.
this is my lord 2004.
It is understood that the cases are kept pending for want of updation, consolidation and due certification by the circle so and so. So far, so after updating and consolidating the fresh list containing 228 names of casual laborers requiring regularization as on date is forwarded herewith.
Yes.
No fresh casual labor is engaged after forwarding the said circle with no fresh cases. Now this list contains the name of 228 persons, including the persons, the applicants. Now, how can you say that these are under the contractors? This is your own list. And subsequently, you admitted that out of this list, 20 persons were granted temporary status.
Your lordship,
And
will-
what they are asking now, they are simply asking, don't pay, don't put us under the contractor. Place us under the BSNL, so they'll get the full salary of month. That's all and nothing else.
Okay.
Regularization, they have already waived, abandoned. And simply they are asking, don't give us 15 days pay, give us monthly pay. That's all. And 39%.
In addition, PLI also you don't want. We have given up that also.
That is also they have given. And what the.
This is, my lord, on 30th March 2004.
Yes.
Now they are saying in 2007.
How can, 2004, once you have admitted these are the persons, casual laborers with the BSNL, how can you deny that? No, they were with the contractor.
Let me clarify
With whom?
from my client.
Yes, sir, last time also we have granted time only for this purpose.
No, last time you,
Actually, there is no clarification for that, sir. These are your documents. You are
Okay.
not denying that.
last time you lordship gave them time to file the affidavit. Give me a little more time, let me clarify it from them.
Sir, what do you-
Regularization to go into control. You can.
Yeah. During the course of the arguments, it is noticed that the Chief General Manager, Northeast Telecom Circle BSNL, in its letter dated 30th of March 2024, 2004 has forwarded a list of 228 casual workers working with the BSNL for considering their case for regularization. Full stop. This list contains the name of the respondent applicants. It is also an admitted position by the BSNL in the by the BSNL wide letter dated 17/7/2023 written by the Assistant General Manager in bracket HR/admin Itanagar to the concerned advocate at Guwahati High Court that out of these 228 persons, 20 casual laborers were granted temporary status. Full stop. Learned. It is noticed that the tribunal, while taking into consideration the above noted facts and certain other facts, has issued a direction to the respondent BSNL to keep the applicant respondents under the BSNL directly and not under any contractor, because while working under the contractor, the applicants are getting only 15 days of wages instead of whole month, as has been paid to the other casual employees of the BSNL. Full stop. At this stage, learned counsel for the applicant, for the petitioners, raise a short adjournment to complete his instruction, whether to complete instructions from the BSNL, that whether the BSNL is ready to keep the applicants under its control instead of contractor. List on 28th of August as part.
My lord, only one thing. Probably I may not heard properly, my lord, that 17/7/23 letter, they say without temporary status they are working. Without temporary status, like us. That's what they say.
No.
Yes, yes.
Just a
Without temporary status. That's why they are equal to us.
Just.
Point number 1, page 325.
325.
Yes, my affidavit.
Whether any person from the concern conferred temporary status, no.
No. Next question
No,
also.
then what is, whether there are any casual laborers,
Without
TSM
temporary
or
status.
list as enclosed election.
So without temporary status they are working. These are without temporary status. This 20. That's the meaning.
So without
Yes, that's the meaning.
उसको change कर देना. Okay, out of those 20, as per the letter dated so and so 17/7/2023 written by the BSNL to the advocate concerned, it is admitted that without granting temporary status, the 20 employees are working as casual laborers with the BSNL. Will correct it.
Item 15.
My lord, your lordship was pleased to give us some time earlier to give the details. Today we have received it and we will file it by way of a additional affidavit. So some short time may be given to us.
Which weeks?
Huh?
Item 16.
Obliged.
If your lordship looks into page 37, the lordship will find 2019-13, my lord, it is Kachari ruins at Kashpur was declared as an ancient monument under section 3, my lord, of the Monument Preservation Act. Now it is under 1958.
Sir, where is the encroachment?
There is encroachment and illegal by the sericulture department.
In fact, is from the photographs you have next. Where are those photographs?
Photographs are there at page, my lord, your 40.
40.
40. And there is a response to it, my lord, by the. Okay. The photograph. You had
Now come to this, page number, annexure 950.
50, that is the monument, my lord.
So that is the monument and it is, there is a boundary wall. And
No, bond-
outside that boundary wall, some houses are there.
Houses are there.
So
The,
if those persons are having their own land,
no, my lord,
we
your lordship will,
prevent them.
no, your lordship will get this report from, my lord, page 44. Is the report from Assistant Settlement Officer. This is a type version. Just a minute, Mr. Yes, Ms. Bora. There was an order passed in the PIL, in another PIL here, constituting a committee at every district level to look into allegations of encroachment in all public institutions, monuments. Where is that order? After that, committees have been constituted. That much, the notification was placed before the court. Where is that? Huh?
No.
Are you aware? I'm not. It has already been done. You have to approach that committee. Headed by the Deputy Commissioner of each district. Deputy Commissioner, as per section 19, my lord, 39, he is the authority to look into it. Page, section 19 of the,
as my lord is saying that
Yes,
there is
yes.
already a order,
I
that
know.
why to pass another order?
let
when
it-
they-
after 1 week, or next week, my lord, I'll look into it, my lord. I'll have to find out that. Mr. Dhar, you also go.
Problem.
Try to find it.
Item 17.
My lord, I'm here with a very serious. I'm here with a very serious,
You are here with the
a very serious and urgent matter of Mr. Digvijay Medhi,
serious and urgent matter.
right? And,
This matter,
right,
what is the seriousness
because
and
bank
urgency?
is going to take over the position of his resident that he has kept it in security for the loan that he has taken. And it is it is nearing the day.
So what's the seriousness about it? It's a usual process. Since you have taken loan, not repaid it, the mortgage property is going to be attached and put to auction.
That's subsequently I'm coming that if I'm allowed
Yes.
to prove that seriously. Basically, Mr. Digvijay Medhi, he is a filmmaker and he produced many documentary films and TV series for Doordarshan and all. And at the same time, he has produced SMS film, which has, brought many laurels for this SMS film industries. That includes an award from IB Ministry and 3 awards from Filmfare Awards, which is specially though in SMS film segment. It was introduced in 2024. Anyways, because of this, disruption in this media business and sudden, technological advancement, he felt the need for upgradation of his media studio business, from where he give rents, this film equipment, filmmaking instruments and editing setup. So thereby he approached Punjab National Bank for loan and seeking around 24 lakhs. Initially the bank is approved, they've agreed to his proposal, and I'm not going into detail. And finally, they end up sanctioning rupees 14 lakhs something. It is there with me. Then subsequently thereafter, when loan was disbursed, so he received rupees 13 lakhs something after deducting those insurances and other charges. There lies the problem. See,
Here lies the problem.
no, my problem. It is not problem, maybe because I sought rupees, how my problem started, my lordship, I'm trying to depict. So actually, I approached a loan amount 24 lakh. Thereafter, I received this much. Again, after receiving this much, some more money was deducted. As per, I don't know what system, they were very intransparent in, deducting those prices and all. It was not known to me. Anyways, thereafter, things started rolling the way it should have been. But after 3-4 months, the loan came into the NPA because he could not pay the regular EMIs. Then somehow he managed, after 3-4 months, he managed to repay that much amount, arranging for that. Meanwhile, the money he had given to a person, a conductor, it is not responsibility of the bank to look after that, I admit. But I'm trying to depict the situation once again. The money he has given to the conductor for upgradation of his studio, that could not happen, and that person did not turn up and do the thing without paying back him the money. But somehow he arranged money, and somehow partially he renovated his studio, upgraded his studio. But that's how he lost his 10,000 bucks. It's a different issue altogether, though.
We have all the sympathies with you.
Yes, fine.
You are a very talented person and bring many laurels to the state of Assam.
Right.
So show us the law that if such a person having such talent,
Right.
if he was granted loan by the bank, then looking to his stature and talent, the bank can't recover it.
No. we
Show us
can't say
any
that.
law.
Right. Right.
That he is a filmmaker and therefore he is not entitled to pay. We'll order this.
In the process, my lordship, we can see, I can point out 5 lacunas from the bank. I mean, I can't say
Please
lacunas,
do
2
one thing,
lacunas.
sir. Do one thing. This is not the proper forum to cure those lacunas or to address those lacunas. The proper forum is the debt recovery tribunal. Go before the debt recovery tribunal. They'll take care of it.
My
They are
lordship, if
equipped
you
with,
give 2 minutes time, my lord, if already you have wasted already time, so I'd like to take 2 more minutes to depict one thing. Thing is that they have violated our fundamental rights because they didn't given us the opportunity to hear us.
Where is you show us any law that before this initiating proceedings for the purpose of this recovery of a loan, they are required to give this notice and they have not followed that. Show us the law.
They have given us the notice, but at the same time, they have highlighted in their notice too, the notice of this positional, I mean symbolic position, the notice they should have given prior to taking up the position of.
Where is that provision? Which is that provision you are quoting? Section 13(4) is there, section 13 is there.
13(4) is there.
So what violation they have committed, and even if though there is any violation, go to the debt recovery tribunal. We are not supposed to look into all these.
Thereafter, one more thing, if I may be allowed to, in section 13(2), in 13(3), it is clearly mentioned that you have to mention in detail the how much amount he is debt like. But whenever they give us letter, it comes with the total amount only, and the borrower hardly he comes.
That point also you can very well raise before the debt recovery tribunal.
I understood you.
You understand, then what remains? You want to withdraw this with liberty to approach the DRT, or will pass an order?
I'm going to go to DRT.
Wants to withdraw with liberty to approach the debt recovery tribunal under the Securitization Act. Granted liberty as.
Item 18 and 19.
Perhaps scrutinize the affidavit, Lordship. Money has yet to be received directly.
What?
Money, compensation amount, Lordship. Is yet to be.
Competition to one person only.
Yes.
1%, it is already, they have moved the finance department for sealing. My instruction is that from home department, it is sanctioned, and it is for sealing, it has gone to finance. Shortly, we will come.
Only one person is there out
Yes,
of 6 persons,
Yes.
5 were granted and
Yes.
one is there, amount is sanctioned but not
Yes, sir.
dispersed.
It will come, immediately it will come.
Yes, what about the second petition? So, we may close this first petition, one petition.
I respectfully submit.
Huh?
It may be closed.
This one, this
Show more, Malad.
239/2024 or 3/2020?
Free of 22, Malad.
3/22.
Two, Malad.
We'll close this petition and
Malad.
we'll hear that petition on merits. Like.
Your Lordship,
Learned counsel for the petitioner has submitted that. So far as regarding the compensation amount in respect of the 6 of the houses which were demolished by the police illegally, 5 persons have already received the compensation amount. However, one person, namely, what is his name?
Rashida Khatun.
However, the Rashida one person, Rashida Khatun, deceased, wife of deceased Safiqul Islam, has not received the said compensation. Mr. D. Nath, learned counsel, appearing for the state, has submitted that as a matter of fact, the compensation amount has already been sanctioned by the finance.
The home department.
By the home department. And the matter is under process. And within a period of, matter is under process, it is submitted that the said compensation amount shall be paid to the to Rashida Khatun, wife of deceased Safiqul Islam, positively.
No, hopefully they said within short period they will do. Give us 2 weeks.
Within a period of
2 weeks.
2 weeks, full stop. Keeping in view of the above assurance given by Mr. D. Nath, we are of the view that no further order is required to be passed in this PIL petition. Therefore, the same is disposed of.
But only instead of 5, it will be 6. The Rasida will be 7.
It's 7. Just see, 5 ki jagah 7, 6 ki jagah 7. Okay, we'll take care.
Deeply.
Your Lordship, on the last petition, the government council has submitted an affidavit. Kindly, if you can, in the annexes they have submitted in the affidavit, kindly go to the page number 38, Your Lordship.
38.
Yes, page number 38. It's the Superintendent of Police SP's report to the Inspector General. Page 38 in the affidavit, Your Lordship.
Affidavit dated
9/8/24, Your Lordship.
in 8/24. Smell the name.
The additional affidavit.
So this affidavit they filed in PAL number 3/2000.
It is filed on, it is filed on 3/2022, Malad. The same issue is there, therefore we said, that it will cover the other case also. Malad, a copy of this may be kept in this file.
Any other document is required to be taken on record from this PAL number 3/2023?
Malad, here the postmortem report and all the medical reports are here.
This is there in this.
Yes, Malad, it is given.
We'll do one thing. We'll keep this affidavit in this PAL number, so and then we'll hear. Okay, and WPC. Sorry, written number of this. Then
239.
it is noticed that in the PAL number 3/PAL show motor 3/2022, which is disposed of today, an affidavit is filed on behalf of the respondent number 5. Respondent number 5 in relation to the incident for which the petitioner Rashida Khatun is seeking some relief from the government. Stop. The affidavit dated 9th of August 2024 filed on behalf of the respondent number 5 in PIL suo motor 3/2022 is relevant for the purpose of the controversy raised by the petitioner in this petition. Therefore, it is ordered that the copy of the additional affidavit filed on behalf of respondent number 5 on 9/8/2024 in PIL suo motor number 3/2022 be placed along with the record of this writ petition. And this after on 30th of August. Yes, Mr. Now this, in fact, this writ petition is taken into tagged with this PIL, and therefore it is listed before the division bench. Now it will go before the appropriate roster for that purpose. By
Lordship, this matter was already listed before single bench, but as the matter is related to custodial death, so it is before your Lordship bench.
Oh, but now this petition is disposed of, so it will go before the appropriate roster. Appropriate roster. 30th of August before the appropriate roster.
Item 20.
May it please, my lord. My lords, I am appearing for respondent numbers 13 and 14. As I pointed out on the last occasion, my lord, the petitioner has filed some affidavit which we inspected from the court file on the 20th of July, my lord. Some additional affidavit has been filed with several new allegations, new documents, my lord. So on the last occasion, my learned friend was not appearing, and my lords could not direct that the affidavit should be given to us. My lords, we should be given an opportunity to file a reply, my lord.
Lordship, the problem is that
You are with you are already in receipt of that affidavit.
No, my lords, we inspected the file, my lords. That's how we got to know.
Yeah.
we will give them the copy, additional affidavit, but anyhow.
This is of 20th of July 2024.
Yes.
It seems like, my lords, those are my instructions,
Additional
my
affidavit that has been filed regarding some new facts, because
Additional affidavit on 20th of July 2024.
yes, I think your lordship.
Okay. The London Council for the petitioners are directed to supply the copy of the additional affidavit filed on behalf of the petitioner on 20th of July 2024 to the council for the respondent number 13 and 14. During the course of the day or when?
Within a week or within 2 3
Within a
days. Within 2 3 days.
London Council for the respondent number 13 and 14 days for. How much time would you like to?
My lords, 3 weeks thereafter, my lord.
to file counter to the said additional affidavit. List the matter after 4 weeks.
Lordship, I have a submission to make because Lordship, what happened during the pendency of this case, we have opposed the stage 1 clearance. The stage 1 clearance is not correct, Lordship. We will submit regarding this. This is not according to the Conservation Act and the rate with the rules. But the problem is that they have been continuing to work topless manner, Lordship, all the time. And they have already installed the electrical tower and also they have put the wire.
Given them the copy of the affidavit of July 2024 in advance.
I don't know why my advocate nurse is not given, but I will check it. That is my.
I'm obliged.
Item 22.
Here, my lord, the petitioner was, my appellant was CIS constable, my lord. She resigned, my lord, on 28/5/2013, and my lord, due to some domestic problem, my lord. On next day, on 29/5/2013, her resignation was accepted, and on 30th of May, she was released, my lord. And subsequently, my lord, after my lord, 1/11/2013, she filed an application for withdrawal of her resignation, my lord. That was rejected on the basis of, my lord, an OM, my lord, office memorandum. Office memorandum is at
On the ground that it was filed after a delay.
My lord.
Or after a period of limitation.
Yes, my lord. My lord, my learned friend wants to file a.
Is there any requirement of filing any counter affidavit?
No, but I have already filed our affidavit in that is, I think in that affidavit.
Yes.
That has been already annexed in the writ appeal matter.
Office.
Is what is that OA?
My lord, OM at page 77, my lord.
77. What it says?
My lord, it says there is a period of 90 days period of limitation is there, my lord.
That the undersigned directed to draw the attention of so and so, it is allowed to withdraw in public interest. Inquiry, the rule provides for conditions under which the appointing authority may permit a person to withdraw his resignation. One of the conditions of absence of duty Resignation became effective from the date person is allowed to resume duty and within no more 90 days. But here in your case, they have immediately accepted the resignation on the
Yes.
very same day.
Yes, madam.
And there was no question of then withdrawal of the resignation. Once it is accepted, then
Yes, my lord, but it says, my lord, that 90 days period is there.
okay,
in
suppose,
petition.
even though if we admit it, but you have not approached them within 90 days.
No, my lord, that is the, my lord.
And April to the November 2013, you filed an application for reinstatement or withdrawal or whatever. it is.
My lord.
They have rejected that.
Yes, my
Then after 5 years, you approached the Jharkhand High Court.
lord.
Jharkhand High Court has rejected your writ petition when?
Oh, my lord, on the ground of territorial jurisdiction, my lord.
When?
When?
My lord, on my lord, 2/4, sorry,
Petition of BRC.
Hmm?
Petition of BRC.
my lord, 14 to 2019.
And then in 2024, you approached this court.
My lord.
Okay.
That is true.
It is-
My lord, my only humble submission is that, my lord, a person, my lord, after rigorous, my lord, the process, my lord, she got appointment and thereafter some,
After almost 10 years. It's, in fact, 11 years.
my lord.
In November, after abandoning service, 11 years have passed. How can we direct them to? Then you will again come for that
Yes, my
11
lord,
years
actually,
period, seniority, salary and everything.
my lord, at that time, there was some domestic problem. That is why she submitted resignation and there was divorce. And now she realized, my lord, then, my lord, that is why.
That she is remarried or not.
No, my lord.
तू remarriage करो और दूसरा परिवार संभालो. It's not.
My lord, now she is only source of income is the, my lord, maintenance. She is obtaining some amount of maintenance.
This writ petition was filed. This writ appeal is filed by the appellant being agreed with the order dated 9/5, order dated 2nd of judgment dated 2nd of April 2024. Passed by the learned single judge in writ petition number 9532/2019. Stop. The appellant has approached the writ court being agreed with the action of the respondent CRPF authorities of dismissing her application for rejecting the prayer of the appellant for appellant for allowing her to withdraw the resignation filed by her. Full stop. The brief facts of the case are that the appellant was recruited as constable in the CISF, sorry,
Yes.
not CISF. On 16/4/2009, full stop, later on, wide order dated 14/9/2020, she was transferred to Dibrugarh. However, while working at Dibrugarh, she filed an application seeking voluntary retirement.
No, my lord, she simply resigned, my lord.
Yeah, while working at Dibrugarh, she resigned from the services wide communication dated 29/5/2013.
28/5, my lord.
28/5/2013, and her resignation was accepted on the very next day, that is on 29/5/2013. Stop. Thereafter, the appellant has filed application before the CRPF authorities on 1/11/2013 seeking withdrawal of her resignation. However, the said application was rejected by the CRPF on 29/11/2013. Full stop. The appellant kept quiet up to the year 2018, and thereafter she approached the Jharkhand High Court against the decision of the respondent authorities, whereby they have refused to allow the appellant to withdraw her resignation. Full stop. The Jharkhand High Court has dismissed the writ petition filed by the appellant on
14/2/2019.
14/2/2019 for want of territorial jurisdiction. Full stop. Again, the appellant kept quiet up to 2024.
No, my lord, the petition was filed 2019.
2019, full stop. Thereafter, the appellant has preferred writ petition before this court challenging the action of the respondent CRPF. Full stop. The learned single judge, having taken into consideration the fact that the application was filed, the application for withdrawal of resignation was filed by the appellant after 90 days. It is also observed by the learned single judge that in the application for withdrawal of resignation, though no exceptional circumstances were mentioned by the appellant, the learned single judge has also observed that the appellant has approached the Jharkhand High Court with at a belated stage without any sufficient reason. Stop. The learned single judge has therefore refused to interfere in the matter. Having heard the learned counsel for the parties and after taking into consideration the above facts and circumstances of the case, we are of the view that the learned single judge has not committed any illegality and not interfering the matter. Hence, there is no force in this writ appeal. The same is therefore declared.
Item 23.
May please, your lordship. But in this case, our affidavit is ready, lordship. By Monday, we will file, lordship. Today, some difficulties, petition respond.
You are for?
Lordship, I am for respondent 1 and 2, lordship.
Private respondent.
Private respondent, lordship. Due to some personal difficulties, he today not able to come for that.
Just after, at the request of the learning counsel for the respondent of 1 and 2, just after a week, interim order to continue till next day.
Item 26.
Lordship, here the respondents have filed their affidavit, Lordship. I pray
Affidavit
that
of what?
I for the petitioner, Lordship. They have filed their affidavit in opposition, Lordship. I pray for 3 weeks' time, Lordship, to file my reply, Lordship. The man is from UP.
After 10 days.
Interim order may be continued, Lordship.
Interim order if any to continue till next day.
Supplementary list, item 38.
My lord, only a slight modification of the judgment and order received first on 6/8/24, my lord, in the 11 of the case. I will place your lordship, my lord. And your lordship will find the judgment and order dated 6/8 on page 19, my lord. The operative part of it. May I read my?
What?
Yes. Page 16, para 16, page 19. It is-
There is no. In fact, judgment is delivered by the.
Yes,
us.
yes.
So
Only,
what
only
we
thing,
need
only
at
thing,
all.
only thing, my lord, your lordship has duly considered. That's my presumption, but that your lordship will find. Para 11, page, my lord, 17. Can your lordship will find. Contending that his client has been out of service since 2007, and therefore at this point of time, his post-trial due is the only relief that he can reasonably expect, since there is no possibility of reinstatement. Because I am age of 69, my lord, now. And only thing, my lord,
Mr. Chaudhary.
my lord,
What the learned single judge has ordered.
proportionate judgment order.
So what we have clarified here.
Yes,
We
your
have
lordship.
simply said, we have confirmed the learned single judge order. You were not aggrieved by the learned single judge order.
No,
You have not preferred any appeal.
no, no.
Then.
Now that in learned single judgment, the honorable court single judge has said the proportionate, my lord,
So where the
punishment.
learned single judge has said, don't this any penalty other than the removal from service be given? Where
Removal,
is
no,
that?
dismissal, my lord.
Dismissal, and we have simply observed that except that penalty, you can impose any other penalty, and we don't find any illegality in the orders.
No, no, or any other
There
penalty.
is no case for review.
My lord, no, I am not for review, my lord, only
So
for
you are only for review
application
or
for
what?
modifications.
Yeah.
To that extent. If my lord, order of removal will be there, my lord, every chances are there, they will remove, they will remove me.
It's altogether hypothetical question.
No,
And
my lord.
situation which you are raising, if they'll do that, then again you come and.
No, no, then it will kindly lordship find, my lord. Para 16, page 19, my lord.
Yes.
The disciplinary authority is directed to pass any other order, penalty 7, except the penalty of dismissal, which shall be so and so.
That's
If
right.
they will pass, you will not, they will not pass dismiss, my lord. Then there are other penalties are there. Kindly your lordship will find. Kindly that your lordship has quoted in the judgment, my lord.
Yes.
Yes.
Have you challenged that order of this learned single judge?
No, learned single judge held that, my lord, the proportionate penalties to be given. But here, my only thing, my lord, only 7 except the dismissal. There are other penalties are there. If they will pass, kindly your lord, I will place before lordship.
Mr. Chaudhary,
My lord.
there are two things, please note
Yes.
before you submit.
Yes.
The order of the learned single judge has not been challenged by
Yes.
your client.
Yes.
Right?
Yes.
Whatever the edict of law is,
Yes.
we are always entitled to enforce it.
Yes.
First of all, the learned single judge has remanded the matter without setting aside the earlier order of penalty.
Yes.
That is a wrong order.
Yes.
If that, on that ground, if it is interfered with,
Yes.
then the dismissal penalty will remain. We did not maintain it.
Yes.
Number two, the learned single judge did not have any jurisdiction to say, impose this proportionate punishment or this or that. The jurisdiction is only when the penalty appears to be shockingly disproportionate. It can be set aside and the matter can be remanded with a direction to impose fresh punishment.
Yes.
Minus the shockingly disproportionate punishment. That's the law. Even if the learned single judge has said anything contrary to that, that will not be effective. The learned single judge cannot dictate which penalty is to be given.
Yes. No.
That's the law. That's what we have read.
No, my submission before lordship, my lord, my humble prayer, my lord. If the order of removal and order of dismissal,
Maybe.
exactly same, my lord.
No.
Yes, my lord. My pension will be forfeiture. Can your lordship
No,
find?
but then you should have challenged the order of the learned single judge.
No, learned single judge has never held that. That's proportionate.
It cannot be done. Learned single judge cannot direct proportionate or disproportionate. Learned single judge can only say the penalty is disproportionate.
No, no.
It is an assumption of law.
No, can your lordship will find, my lord. The learned single judge has held that, my lord. Your lordship will find.
Yes.
The retaping is there.
Yes.
Retaping.
You read.
Yes, my lord, can your lordship will find. Your lordship, page 166.
Yes.
Accordingly, this matter is remanded back to the disciplinary authority of the respondent bank to take appropriate decision on punishment to be inflicted on the petitioner proportionate to his conduct, that he has acted in a manner by which he had disobeyed the instruction of his higher authority, but that has caused by the financial loss to the bank, or petitioner has indulged any undue financial benefit for himself by doing so.
So proportionate means not removal, but anything less than that.
Yes.
Where does it say, where is it
No,
mentioned?
that he has not said. But my submission before lordship, my lord, here, my lord, only dismissal or accept the dismissal. My submission before lordship, my lord, your lordship is very much aware. The order of removal, order of dismissal, gravity is exactly same. My pension and retirement benefit will be forfeiture.
No, in removal it will not be.
Yes, my lord. I object it, my lord. Your lordship is very much aware. I need not to say anything before lordship, my lord. Only my humble prayer, any other penalties, they may give except order of dismissal and removal. That is my humble prayer.
Then this order has to be challenged. Give you order.
This is my humble prayer, if your lordship.
Having heard the learned concept for the petitioner, review petitioner, we don't find any error apparent of the face of the record, and its review petition is dismissed. That the relief that you are seeking, that can be only granted by the higher forum. We are sorry, legally that argument is not acceptable.
Well, only
Neither the single judge.
My lord.
You should have challenged the learned single judge.
The learned single judge has given
He should have clarified.
Proportionate, my lord.
Except removal and dismissal, any other punishment.
Then I have a small prayer before lordship, my lord. My submission, my presumption is that, my lord, if they will pass an order of removal, then liberty to give to me, my lord.
Always there, sir.
No.
There is no question of granting any.
No. This will restrict me, my lord. Accept the penalty of dismissal.
We don't find any case for error apparent on the face of the record, hence the review petition is dismissed. However, the appellant, if the applicant is at liberty to initiate appropriate remedy against the fresh order of punishment passed by the respondent, passed by the bank concerned in accordance with law. Fresh order of penalty, if any, fresh order of, in accordance with law.
Item 39.
Your Lordship, again, the order of the learned single judge, Your Lordship, on the two grounds. No opportunity of hearing has been provided to the petitioners. And second, the order dated 31st January 2024 was supplied with the notice dated 31st July 2024. And they have said that that was the speaking order. And there was no speaking order because no opportunity of hearing has been provided. There were 188 members, Your Lordship, and they have given only 5 hours, and they have called the petitioners to make signature on their register. And there was no opportunity has been given, Your Lordship. On these two grounds, Your Lordship, this writ appeal has been filed.
The writ appeal is still pending.
My lord.
That is pending. Writ petition is still pending.
Writ petition is still, but
Your
Lordship, learned single judge has rejected.
Rightly so.
Interim.
Rightly so.
My lord.
Rightly so.
No, that was not right, Your Lordship.
That is, that is your prerogative. You can argue.
My
But
lord.
we feel that rightly so.
My lord, the Honorable Apex Court, Your Lordship, has granted against the review petition, Your Lordship, had granted and also restrained the inaction of the respondent in pursuance of notice dated 31st July 2024, Your Lordship. Kindly have.
The Supreme Court has already granted, then why you are here?
No, Your Lordship, because thereafter, after filing this petition, Your Lordship,
Yes.
after filing this petition before the single judge and before Your Lordship,
Yes.
This order has come into the existence, your lordship.
Then what remains? If the Supreme Court has passed this order, then where is the, why you are coming here again?
Your lordship, what happened after challenging the review petition ordered at 31st?
38, then what remains, madam? Now the Supreme Court has restrained them. Then why you are pressing this petition even?
Your lordship, it was the process because after
Till
31st,
next date of hearing, the members of them shall not be disclosed from the spaces under the occupation and they shall be allowed to go without prejudice. Then what remains?
your lordship, what happened? Again, the order dated 31st May 2024, the petitioners have approached there, your lordship, Supreme Court. But thereafter 2 months, your lordship, they have issued the fresh notice without disclosing. That's why the
Even though
that's why the petition
they
had to approach
issue
before this.
100 number of notices, this Supreme Court stay is already there, whether they can remove.
No, your lordship, what happened before day after tomorrow? Otherwise, there was no need to, your lordship, file the writ appeal or that writ petition, your lordship.
Since in view of the stay order passed by the court, no, there is no reason for you have to pursue this appeal.
Well, because that petition is also pending before the single judge.
Yes, my lord. In fact, suppressing various facts.
There is no, your lordship, everything has been disclosed.
Not at all.
Because in the order because the order of the single judge itself stated that there is no stay order before the Honorable Supreme Court.
Yes, confirmed.
Yes, it has been stayed, my lord.
Your
Some
lordship.
interim protection has been granted on 13, my lord. On 12, they filed the writ petition before the learned single judge, and on the same date, my lord, they had moved the IA. So
That's another thing.
Because that was
this writ appeal is filed by the
this is
appellants
basically
being
becoming
agreed, being agreed with the order dated 12/8/2024 in writ petition number 4083/2024, whereby the learned single judge has refused to pass any, refused to direct the respondents, railway authorities not to dispossess the appellants from the shops, from the spaces under their occupation. Full stop. Learned counsel for the parties have submitted that the Honorable Supreme Court in special leave to appeal number so and so from you get it in the details from this has on 13/8/2024 has already ordered that the members of the petitioner appellant association shall not be disclosed from the spaces under their occupation, and they shall also be allowed to carry on business without prejudice to the rights and contention of the respondents. Full stop. The parties have submitted that the in view of the stay order passed by this court, by Honorable Supreme Court, no further order is required to be passed in this writ appeal. Hence, this writ appeal is disposed of.
one clarification, ma'am. This order by the Honorable Apex Court is not passed in the SLP, it's passed in the IA, my lord.
Okay, we will note this. Na? Yes, note that. Arising out of certain situation. The IA number.
Not sure.
Deep reverence.
Daily list for hearing item 27.
I also asked to prepare.
If the appeal preferred by the state, and the question for determination before Lordship, whether
This is
No.
by you.
this is by my land single.
I yes, my lord.
One
You
thing
also
I-
directed me also, my lord, to prepare, my lord.
Yeah,
So that is why
The amount is same, but with regard to years, my land agreement says that avail during 1/10/2009 to 31/10/2010.
which is just of notice also.
wait, what is this?
This is Lordship, what happened here,
What you have supplied?
Myself. Your losses also directed me, my lord, to show when it was utilized and.
Okay,
fine. That is why. Along with my lord, the judgments of the Supreme Court. Second page.
Yes. What's it here, the question whether the demand is barred by limitation, whether extended period invoked by the department is correct or not. What's in for that, let's see, page 19. 19. It's a part of Soko's notice, last paragraph. Whereas it also appears from the above that the notice has been taking ineligible sandwich credit with effect from October 2009, and after partially utilized the sandwich credit reverse the amount over which so and so on 30/11/2011, but the interest thereon is not yet paid. Rule 14 of the sandwich credit rule 2004 stipulates that where sandwich credit has been taken and utilized wrongly, the same along with the interest shall be recovered under section 75 of the Finance Act 1994. Whereas the notice has reversed the principal amount on their own assessment, and in the interest thereon rupees so and so is then recoverable from them. Then let's see page 20, first paragraph. And there is a summary of the amount. Next paragraph. Why let's see we have invoked the extended period that has been explained here.
Audit objection was then only you have raised this show cause notice.
Yes, let's see.
Prior to that, you have accepted that ST3
No, let's see.
return.
In SC3 that was not disclosed, let's see. Only
They
after.
have disclosed.
No,
This is what their case is. And you have also admitted that yes, they have disclosed, but there is an intention to evade or this is what.
Under rule 14, lordship, under rule 14 of sandwich credit, they cannot utilize, they are not liable.
They are not disputing that. They are saying, yes, we can't utilize and we have utilized this wrongly.
Then lordship page 20, lordship paragraph, first paragraph. Whereas it appears that the utilization of sandwich credit rupees so and so, and service tax so and so, education so and so, aggregating rupees 1 crore 30 lakhs, so and so, only for payment of service tax is not permissible in term of the provision of sandwich credit rule 2004, and the same is liable to be recovered under rule 14 of the sandwich credit rule 2004, read with provision of section 73(1) of the Finance Act, along with the interest thereon. Under section 35 ABD invoking extended period of 5 years for contravention of rule 14 of the sandwich credit rule with intent to evade payment of service tax, and hence they are also liable to penal action sanctions. This is the notice, lordship, the order in original, lordship. Page 26, lordship, paragraph 2.13.
come to this page 29.
Yes.
There are 4.6.
Yes, 4.6. Lordship, may 4.5 also I want to place. On perusal regarding the first aspect, where such sandwich credit can be taken or utilized by the said notice, it is observed that the said notice have never argued disagreed with this fact. Instantly, they have submitted that the credit under dispute was taken with bona fide belief that the same are eligible for credit under sandwich
They
credit.
are not challenging that. They are saying this, we have wrongly availed it. They are admitting. They are simply saying that we have mentioned everything in our ST return.
It is there, that is their case.
And that is their case.
Yes, sir.
And every detail was there. They have, under a bona fide belief, they availed that Senvet credit that it is applicable where it was not applicable. Immediately after order of objection is reversed them.
They reverse them.
And after 3 years and something, you issued the show cause notice, which as per them
It
is barred by limitation.
Yes, Lordship,
This is not the case.
we have extended the, we issued a notice invoking the section 73(1) proviso. That is a fraud because they're under the sanitary rule 14, they were not entitled to. And that's why.
Disclosed it. Where is the fraud? They have disclosed it.
No, we have.
They have disclosed it. Now, you just come to page this 4.6.
Yes, regarding whether the wrongly utilized certificate is recoverable along with the interest thereon in term of proviso to section 73 or 75 of the Finance Act 1994
Last line.
by invoking
The
extended
said noticee claimed that they had submitted
ST return
along with
the relevant record.
and the
Documents,
documents and no facts were suppressed or misreported. Moreover, they have submitted that
Yes.
credit under dispute was taken with bona fide belief that the
same are
same
eligible for the credit.
are eligible for credit under Senvet rules, credit so and so, so and so.
Yes, sir.
In the relevant return, as well as the and utilized were duly reflected in the relevant return, and as well as submissions of the said return were duly made to the proper office enclosing all the relevance where the details of the credits were reflected and credits were knowledge of the department. No objection was raised by the department. Has ever said the credits were irregular until audit objection was received.
Right, so and so.
The objection in question was raised on 28/3 after 2 years, 11th month. In this regard, I find that mere submission of return may not be sufficient obligation for the. How can it be, sir?
No, so thereafter.
It is not the finding that he has not disclosed all these.
There is a
Read.
There may be some element of misstatement or suppression of facts, which may happen even after regular submission of ST3 return. Hence, the department is required to investigate or to audit an SEC under the umbrella of department. Besides, I find that the said notice has taken and utilized ineligible Senvet credit in violation of the provision of Senvet credit rule 2004. They even did not reverse the wrongly taken Senvet credit until audit had pointed out. After the completion of the audit, they reversed the amount of Senvet credit which was not utilized up to the date of audit. Had the audit not unearthed the fact, it would have been remained hidden. Therefore, I find that there was
law point. Okay, even though if there is no suppression, extended time of limitation is available.
I want to place one judgment.
That would be sufficient. And Mr. Saiwala, do you have any other thing?
My lord, I have the judgments, my lord, not that time, but I have given the list also. I have got that copies, my lord.
Let me copy of the two.
My lord.
I have one judgment, Lordship.
When there is no suppression.
No, Lordship, that is correct. But if
that is correct, then limitation, extended period of limitation is not available.
Lordship, if there is a violation of Senvet credit rule, the Supreme Court says that extended period can be inferred. I'll place that judgment for
In that case, where there is a suppression.
No, Lordship, that is a case. I want to place section 73 of Finance Act 1995.
Yes.
Finance Act 1994, section 73. Section 73 provided, there are 5 grounds are there for extending period of limitation laws. Fraud, then misstatement law.
Willful misstatement.
Lordship?
Willful misstatement.
Yes, Lordship. Lordship, finding is that with regard to that, there was a misstatement.
Misstatement.
Yes,
Not
misstatement.
willful.
No, Lordship, the word is not used by authority, Lordship.
What is not there? Since there is no willful misstatement, therefore what is not there?
Lordship, I'm relying on judgment of Supreme Court, paragraph 15.
Yes.
2007-10 SCC page 3. Only paragraph 15 lots. Paragraph 15 page 8. Married law. Before concluding, we may add that every efficient manufacturer has to plan his.
Paragraph 8.
Lordship.
Paragraph 15.
Paragraph 15, Lordship, page 8. Last page.
Yes.
Before concluding, we may add that every efficient manufacturer has to plan his operations sufficiently carefully to know what raw material he uses and in what proportion he will use the raw material in the manufacture of his final product. Generally, such manufacturers maintain what is called as order block. A manufacturer has to who is prudent would ordinarily work out on estimate the extent of exemption which is likely to get in which event the uncertainty to which the learned counsel has made reference would in fact hardly arise. In the present case, we are concerned with the amount of deduction. The deduction has been claimed by the SCC manufacturer appellant. The burden is on such manufacturer to maintain proper record as to the burden is to file a proper price declaration under Rule 173C. The burden to claim deduction is on the manufacturer. In the present case, the SSC has filed declaration under said Rule 173C without disclosing to the department any of the aforementioned details. We therefore of the view that the department was right not only in raising the demand for differential duty, but also for invoking extended period of limitation. And Lordship, the facts of this case are also almost similar, Lordship. Although,
sir, without, in the present case, the SSC has filed declaration under said rule without disclosing
yes, Lordship, the rate
to the department any of the aforesaid details. Here, the case is that he has furnished all the details that he has availed this Senate credit. Ultimately, he says bona fidely, wrongly, I have availed that though it was not exempted.
and under Rule 14, he is not entitled to it. That is the basic difference here in this.
This is what the case is.
Lordship.
This is what your case is?
Yes, Lordship. Yes.
Yes.
And Lordship, finding of the authority that there was a misstatement, willful word is not used, Lordship. That is.
Misstatement, no, sir, not misstatement. The finding is altogether different. They have gone to the extent that if that ordinary objection would not have been raised, then certainly he would have availed that.
That is the
all these things.
That is the ground taken by the authority, Lords, for invoking
Yes,
extended.
yes, yes. Yes, Mr. Sahib.
I am also relying on 7. This is also allowed. Just that. Paragraphs I have given the melody note, second page. First judgment is 23-8 SCC, 483, my lord.
2023 8 SCC page.
483, my lord. Paragraph
Oh, yeah.
110, 11.
Paragraph?
Paragraph 110, 111, 129, 180. My lord, in the, my lord, a note I have given that, my lord. Second page of the
That paragraph page बता देना sir.
page, I'm confused.
Page?
Page, well, it is, it started page 483,
Yeah.
but it is at page, my lord, 110 is, my lord, at page,
Paragraph 110.
yes, my lord. Paragraph 110.
Yes.
Yes. Unseverely Finance Act is 18 months from the date relevant date. However, provision 73 for willful suppression by a person, then another to 5 years. The contention of respondent, there was no positive act by it. There was only mere inaction. It was further contended that the department was aware for the receipt of the internship fee by the respondent by swing bank. Their audits, these arguments have been rejected by the commissioner by relying on the law laid down by so and so. This. The aforesaid decision was rendered under section 11A of the Act. The 11th provision of the 11A in this regard are preliminary to the corresponding provision of 73 of the Act. Suppression is found in both the statutes as a ground to extend the period of limitation. In the aforesaid judgment, court held that period begins with the knowledge of the department. While on suppression, I may notice the judgment of this court in so and so and so. Bajaj Auto Limited. Section 11A empowers the officer to initiate proceeding where duly levied or short levied within 6 months from the 11th day. The proviso 11A provides extended period of limitation provided due not levied or paid, which has been short levied or short paid or universally refunded if there is fraud, collision, or willful misstatement of suppression of facts or contamination of any provisions of the Act or rules made thereunder with the intent to evade payment of duty. The extended period so provided is 5 years. Since the proviso extends to period of limitation of 6 months to 5 years, it needs construed strictly. The initial burden is on the department to prove that the situation visualized by the proviso existed, but burden shifts on the assessee once department is able to produce material to show that the appellant is guilty of those situations visualized as section so and so. In CC so and so, these are the quoted, my lord. Now, your lordship may come to my lord this one of this judgment of para 18, my lord. Para 18 that Anand Nikosal case has been considered, my lord. We find that suppression of acts can only one meaning. The correct information was not disclosed deliberately to evade the payment of duty. This is the, my lord.
Where you are reading?
My lord, at page, my lord, 548, subpara 18, my lord.
Subpara 18.
Yes, that judgment also I relied on, my
Therefore,
lord.
the upshot of the above discussions.
Yes, Anand Nikosal case, my lord.
For the.
We find that suppression of facts can have only one meaning. Page 548, my lord. That same para, my lord. Para 111.
111, yes.
Yes, but that continues, my lord, that several judgments refer to.
Yes.
Subpara 18, my lord. Yeah, Anand Nikosal Committee Limited observed that we find that suppression of facts can only have one meaning. That correct information was not disclosed deliberately to evade the payment of duty. This is when the facts were known to both the parties, omission by one to do which what might have been done and not he must have been done could not render its suppression. It is settled law that mere failure to declare does not amount to willful suppression. There must be some positive act from the side of the assessee to find willful suppression. In our view, on reading of the relevant provision, the extended period limitation as provided under section 11A1 of the Act can only be invoked when there is a conscious act of either fraud, collision, willful misstatement, suppression of fact, or contravention of the provisions of the Act or any rules made thereunder on the part of the person chargeable with the duty presented with the intent to evade payment of duty. In the present case, the tribunal, while considering the issue, has not stated whether or not there were any such circumstances which should not allow the revenue to invoke the extended period limitation. It only observed that in the order that since both the SSC are situated under the jurisdiction of same division, as such, there cannot be reasonable to conclude that revenue was not aware of the transaction, since this was not so. Now, my lord, next.
What about the other view?
Para 179.80, my lord.
179 and 80.
180, yes. Last page, my lord. As regards revenue allegation of willful suppression, the settled view of the court is best explained in the following extract of previous judges ruling in Cosmic Day versus so-and-so, where it was observed the intention so-and-so to section 11A, which permitted section 73 of the Finance Act. Now, as so far as the fraud and collusion are concerned, it is evident that the requisite intent to evade duty is built into these very words. So far, misstatement or suppression of the fact are concerned, they are clearly qualified by the word willful preceding the words misstatement or suppression of fact, which means that with intent to evade the duty. The next set of words, contravention of any provisions of this act or rules, are again qualified immediately by the following: with intent to evade the payment of duty. It is therefore not correct to say that there can be a suppression or misstatement of fact which is not willful or yet constitutes a permissible ground for purpose of section 6. The New Textile Limited, the conclusion that mere non-payment of duties is equivalent to collusion or willful suppression of fact is, in our opinion, untenable. If there were true, we fail to understand which form of non-payment would amount to ordinary default. Considering mere non-payment as any of the three categories contemplated by the proviso would not leave the situation which limitation period of 6 months may be applied. In our opinion, main body of the select section in fact contemplates ordinary default in payment of duties and leaves cases of collusion, willful misstatement, suppression of fact, a smaller, specific, and more serious to the proviso. Therefore, something more must be shown to constitute the act of possession. Therefore, with regard to revenue allegation of willful misrepresentation, I find no merit, given that so the allegation or scope of so-called notices. Moreover, representation sent by the Indian Bank Association, the Joint Secretary, Central Board of Excise and Custom confirmed that there is a lack of clarity with regard to the method of payment of this tax, for which there was an ongoing dialogue between the banking institution and the central government. I think that claims.
Yes,
The other cases are also there, my lord.
those which
Yes, 2005 9 SEC.
2015.
59 SEC, my lord, paragraph 18 to 20.
18 to 20.
Yes, my lord. It is at page 126. Added to this, the appellants have clearly stated that not a single transmission assembly has in fact sold by them in the market. Of these facts, the opinion of the appellants would fall within the case law laid down by the judgments in Padmini, so and so. My lord, the Sri Bengal Learned Counsel for the appellant drew Parsons' observation of the so and so in CC versus Temple Drugs and this court observed that in order to sustain an order of tribunal, a period of 6 months after a period of 5 years, in view of the proviso of section 1 of subsection 11A, has to establish that duty of excise has not been levied or paid or short levied or short paid or erroneously refunded by reason of either fraud or collusion or willful misstatement or suppression of acts or contravention of any of the provisions of the act or rules made thereunder, with the intent to evade the payment of duty. Where my lord definitely.
Yes. Next.
Next, my lord, the judgments are there, my lord, 2013 9 SEC also there, my lord. Same line, my lord. Para 18, my lord.
This is also para 18.
Yes. Paragraph 18. Here also cosmic, my lord, has been considered and others.
Mr. Sahil, what are the facts of that case, the judgment you are referring to?
Facts, my lord, in this 13-9.
Yes, yes.
By the time. Lord, para 2, my lord. The appellant experimented engaged in manufacture of all wool And Bollywood, what is, it was grounded status from EU Government of India, Ministry of Industry Department, by letter of so when the appellant applied for license for private responded to the house, which was granted.
Yes. That's all.
Well, the others are also there, on the same line, madam. 2007, 10 is earlier judgments, madam.
You already,
Same line, madam.
yes. What is that?
Item 28.
My lord, in this case, my lord, in fact, my lord, what happened? The petitioner's case was considered for promotion, my lord, in 2011, but it was not considered by the DBC. So they filed a case, my lord, representation before the Calcutta High Court, and Central Government Council gave an order that his case will be considered. A review DPC was constituted, but review DPC, my lord, recommended for promotion from 2015-16, my lord. Thereafter, my lord, even then, my lord, even if 15-16, my lord, 2020, he is eligible for the next higher promotion after 4 years. But in the meantime, my lord, they have given ad hoc, my lord, not promotion, but ad hoc appointment to various persons. But he has not been given. My lord, the persons who are not eligible to be.
Dog, removing one ad hoc with
No,
another ad hoc. What's the problem?
No, that is my lord, the single judge has said, but subsequently they have removed. No, they have changed, my lord. Even after the judgment of the single judge also they have changed, and a very junior officer to me, my lord, he has been given. I have asked my learned friend, my lord, that he may be considered for ad hoc promotion, my lord, because very junior. So he said that
Not
he will take.
promotion, sir, it's only ad hoc arrangement. Not
He
even promotion.
no,
Promotion,
but-
the central government has already banned promotion and everything.
So my learned friend said that he will take instruction, my lord, if ad hoc.
No, where is the question of this? Why should, what instructions he is required to take now?
No, my lord.
That single judge
Ah.
has negated your argument.
No, that was, he was removed, my lord. He has been removed, the another person is appointed. He also been removed. The another person is appointed subsequently.
So that's a fresh cause of action.
No, my lord, my learned friend, my lord, I have told him, my lord, he will consider that he will talk to my lord, the department that if he can be accommodated on that basis, my lord, because after all, he's the senior person, my lord, he's the senior most person.
You do one thing.
Yes.
You withdraw this writ appeal, will grant you liberty to represent, to provide you, and they'll consider it.
My lord, let it come up on Tuesday, my lord, he will take instruction.
What is the need of his?
No, my
what is the
learned friend said
validity
that.
in the judgment of the learned single judge.
No, that is correct, my lord. I'm not denying that, because they should have considered constituted DPC in 2020 itself. If DPC would be.
Sir, you have not challenged that DPC order.
No,
That
earlier-
promotion, by which you were granted promotion in the year 2016, you have not challenged those proceedings.
No, now, my lord, they should have considered the DPC for the next promotion in 2020.
Next promotion, there is no question of next promotion. State central government has already this ordered for abolition of the post and said.
So, my lord, only 2 days, my lord, your losses may fix it on Tuesday next. My learned friend may take instruction, my lord.
Sir, learned friend, where is the question of taking such instructions?
My lord, he said that, my lord, on ad hoc basis.
Yes, Mr. Kayal. Have you assured him?
Lordship, we are just looking each other.
He'll file a representation, you consider it.
Yes, that will do.
My lord.
After attempting to argue the matter.
Right. The officer was for a single bench, my lord. He was removed in 19. And 23 person appointed, my lord, he is much junior to him.
That is, we understand, sir, that they have this ask the person to perform the duties of assistant secretary to an officer who is junior to you.
Much junior to me, my lord, but I am ready also, my lord. It is not that, my lord, I am not ready.
No, but
So,
for that reason,
my lord,
you may approach them and they'll consider it.
my lord. And they may,
Legal and counsel for the after attempting to the matter for quite some time, learned counsel for the petitioner has submitted that. Appellant has submitted that though the appellant has raised a grievance before the learned single judge that one officer PC Boro, one officer Mr.
PK Das.
Hmm?
PK Das, my lord. In the first page, it is there, my lord.
PK Das.
Yes.
One officer PK Das was much junior to him, but he was assigned the duties of assistant secretary, duties and responsibility of the post of assistant secretary. Full stop. It is submitted that after decision of the learned single judge, the respondents have assigned duties and responsibilities of assistant secretary and estate officer. Then assistant secretary and estate officer पहले भी लिख देना है to a person much junior to him, to Ashish Dev.
Yes, Abhishek Sharma, my lord. Abhishek Sharma.
Mr. Abhishek Sharma, who is much junior to him. Full stop.
Then thereafter, assistant. Thereafter, 23 assistant.
Yeah, to a officer much junior to him. The name not much junior to him. It is much junior. Officers much junior to assign the responsibilities and duties of assistant secretary of the post of assistant secretary and key estate officer to the officers much junior to him. Learned counsel has therefore submitted that he may be allowed to withdraw this writ appeal with liberty to move appropriate representation before the respondents with a prayer to assign him the duties and responsibilities of assistant secretary and estate officer.
No, assistant secretary. Assistant secretary.
Assistant secretary in place of the junior, in place of
Assistant.
the officer junior to him,
Assistant.
junior to him. Full stop. Mr. Kayal has submitted that if any such representation is filed by the appellant, the same shall be considered by the respondents objectively and expeditiously. Full stop. In view of the above, this writ appeal is dismissed as withdrawn with liberty to the appellant to move appropriate representation for ventilating his grievances. It is expected that if any such representation is filed, the same shall be considered by the respondents objectively, objectively, and will be disposed of expeditiously preferably within a period of 2 months from the date of filing of the representation.
Item 29.
So this is a appeal by the revenue. In spite of receipt of notice, nobody appeared on behalf of the respondent.
Admit bhi ho gaya, uske baad mein bhi nahi aaya.
Yes, and notice has been properly served. There is a note of the office note. Okay, fix another. Permit. The here question is lordship addition under section 147 explanation 3, and that point has already been decided by different high court lords.
And all the high courts were consistent on this view that explanation 3 will not.
Addition can be made. I've one judgment is applied that is on available on the record. Punjab and Haryana High Court. Lordship.
Punjab and Haryana High Court.
Lordship. Mahak investment. Commissioner of Income Tax versus Mahak investment laws. Paragraph 5 and 6.
What about the other high courts?
Other high court lordship, another judgment is there. That is of Karnataka High Court. Same that Mahak has been relied on. This is the Karnataka High Court.
And which high courts have taken contrary view?
Not that I have not brought that judgment.
What? The monarch to dono dekhne padenge.
Not say me fixed on Monday. I'll place all the judgment. But the Punjab and High Court judgment is followed by all the High Court.
No.
Probably Allahabad High Court taken different view then.
This Bombay High Court has also taken a different view.
That I have not brought. Lordship may taken on Tuesday.
Sir, in this judgment of the appellate authority, which is that authority? This judgment which was under challenge before the CTAT.
Lordship.
Or ITAT, whatever.
ITAT.
ITAT.
Lordship.
This he has referred to come at least Delhi High Court, Bombay High Court, this Commissioner of Income Tax Appeals.
Lordship.
Page 57. Yeah, this internal page of 24 of the judgment.
That is by the assessing authority.
Not SSC.
Appellate authority.
Appellate authority. We seek to place reliance on the following judgments.
Bombay High Court. Lordship.
Yes. And all these judgments says that the unescaped income cannot,
Cannot
which is
be-
not reflected in the this
Yes, Lordship.
that can't be taken into
But
consideration.
Lordship, the explanation 3 has not been taken into consideration.
Explanation 3 को ही इन्होंने किया है सर.
No, Lordship, probably.
Page 50 आप देखें page 24. Appellate authority का internal page 24.
Yes, Lord.
We seek the place of following the CIT explanation 3 of the section 147 of the Income Tax Act.
Was inserted by Finance Act 2009,
Yes.
which effect from April to 1929. The effect of the explanation is that even though the notice has been issued under section 148 containing the reasons for reopening of the assessment does not contain reference to a particular issue with reference to which it has been escaped assessment. So thereafter there are 3 or 4 high courts.
Then
That,
Delhi High Court again same view,
Yes, then Betsy.
and both these judgments have been taken into consideration. The same view.
Yes, but Karnataka High Court, Punjab and High Court, consistent view is that can be added under section 147 explanation 3. Let's say consider all the judgments are. Let's say page 7 of Karnataka High Court. And the
No Supreme Court judgment on this point.
let's say I didn't find any judgment on this point.
This Karnataka High Court and Punjab and Haryana, the contrary view. You please place
Yes,
those
sir.
judgments.
I'll place all the.
Mr. Afghani.
Item 30.
My lord, possible for the time being, I'm led by Mr. K. M. Chaudhary, senior boy. He's on legs, my lord. For
Don't
time
have any
being.
other case.
I am for the respondent, my lord. 38-year-old young man dismissed from service, Learned Single just reinstated him, my lord.
On the basis of vague charges.
On the, yes, my lord, that it was the vague charges, the ground of allowing the writ petition, whereas our contention was that the charges were not vague, it was very much specific. As your lordship will go through the memorandum of charges and article of charges, my lord. And their plea was in the writ petition that the charges was disproportionate. They have not taken this plea that
Disproportionate charges.
the order was, the dismissal order was disproportionate to the charges level, my lord. It was their plea in the writ petition.
Only plea.
Yes,
No, my lord. There were
But
3, 4
this plea
grounds.
was not there.
There were 3, 4 grounds. One is vagueness. My lord, normally court, what your lordships do, my lord. 1, 2, 3, 4, 5 grounds of challenge. Lordship, when your lordships are satisfied that no, this ground is good enough, we need not address the other. This happened. The learned single judge thought that good enough ground, these charges are not paid.
Next week. Next week.
Maybe taken up. Joint proceeding nine persons. Others were allowed to go scot-free with lesser punishment. And my lord, this young man was punished with no future employment. Made a scapegoat actually.
Let us.
Item 34.
We'll consider whether charges are take or not. That's only.
Yes,
That you know, I'm here to defend the learned single judge. Next to me.
May it please your lordship. Also, for little accommodation, lordship, advocate general is not feeling well, lordship. He is sitting in his room, lordship. Not feeling well, so lordship may any other day, lordship.
Who is not feeling well?
Learned advocate general is not feeling well.
What happened?
He's suffering from fever, lordship, and he's even doing the cases also. Just now in court number 10, he has finished one matter. After that, he's feeling not well, lordship. Yes.
So lordship, if it is not inconvenient to your lordship, can we have it on 27th? Next to next week, lordship.
Lordship. Oblige, lordship.
Item 35 to 37.
Yeah, please, my lord, here also I am making a similar prayer, my lord. I am led by learned advocate general. My lord, he is developing fever, my lord.
2 years.